One, this is Advocate Pawan here. So, as part of your upcoming exam, today we'll be dealing with the most important questions. And I want all of you to prepare properly, just focus and then answer to all my questions accordingly and then prepare. We are going to discuss only the important questions starting from CrPC, then couple of other laws here and there. Mix will be taking it up and we will be preparing. So, these are the most repeated questions being asked for the exam again and again, not only for the present exam but also from the other parallel kind of exams which you've been preparing for. So without wasting any time, let's start. So a small request, if you're new to the channel, please do like, share and subscribe. I'll be posting many similar videos as this just for your preparation to become very easier. Let's start. If a police officer after investigation finds that a case he inquired into discloses the commission of a non-cognizable offense, what status does his report get under the CrPC? Very simple. So the answer is a complaint. Okay, very simple. If it is a non-cognizable offense, by default, it is considered to be what? A complaint. Why? Where a police investigates a non-cognizable case after magistrate's order and submit a report, the police officer report is treated as a complaint and the officer is treated as a complainant. Very simple. Okay, very simple. If I'm a police officer, if I'm investigating on a non-cognizable case like after the magistrate's order and submitting a final report, and that is considered to be what? It is purely considered to be what? It is considered to be a complaint, and that police officer will become a complainant. Now, second question. Next important question is about directions and anticipatory bail. Okay, this is something on that particular grounds. Question is, under section 438 of the CrPC, anticipatory bail, what is the correct direction that a high court or court of sessions gives to the arresting authority? Okay, under section 438 of the CrPC, what is the correct direction that a high court or a court of session gives to the arresting authority? Four options is given. That is about very simple. Let's go to the answer. In the event of such arrest, he may be released on bail. Okay, anticipatory bail means what? It's a very common sense question. If you look at the options itself, you'll be able to read across. An order under section 438 is direction that if a person is arrested, he shall be released on bail. So it does not prohibit arrest itself. Okay, very simple. By heart, this important section 438 of the CrPC tells about what? Anticipatory bail. And also, as per the BNSS, what does this particular section say? Let me know in the comments. Okay, third question. Now, under CPC, in which situation can a civil suit not be dismissed? Under which situation, Civil Procedure Code, can a civil suit cannot be dismissed? First is about what? Where the plaintiff fails to pay the prescribed court fee for service of summons. B, where the defendant appears in court on the day fixed without being served with summons. C is about where neither party appears when the suit is being called for hearing. D is about where the plaintiff fails to apply within 7 days to issue a fresh summons after the previous were returning unserved. The answer is very simple. It is option B, where the defendant appears in the court on the day fixed without where the defendant appears in a court on the day fixed without deceiving serving with summons. Explanation: if the defendant voluntarily appears, service purpose is achieved. The suit is generally not dismissed for that particular reason. Okay, so in that particular reason, obviously suit is not dismissed for that particular reason. Now, whereas in other particular reasons, for example, where the plaintiff is not paying the court fee, or if for example, if he's not where neither party appears for the hearing, or for example, if it is like where the plaintiff fails to apply within 7 days of issue of fresh summons after the previous unreserved, then obviously that is basically a grounds for what? For the entire suit to be dismissed. I hope that's very clear. Learn order 5 and order 9 properly. Now, fourth question. I hope my screen is very big visible to you. Yes, I'll just make it a little more big. Okay, this better. The cognizable required complaint by agreed person. Now, we'll just deal with the question with CrPC now. For which offences shall the court take cognizance only by a complaint made by some person agreed? Okay, very simple. Is it for theft, rape, criminal breach of trust, or offences related to marriage? Option D, that is about offences related to marriage. Section 198 of the CrPC, offences under Chapter 20, offences related to marriage are generally cognizable only on complaint by person agreed. So person agreed person can also file a particular complaint over here. Very simple as it. Fifth question. Sentencing power of Chief Judicial Magistrate. Okay. The Chief Judicial Magistrate may pass any sentence authorized by law except death, life imprisonment, or imprisonment exceeding 7 years. Very simple, okay? So remember, Chief Judicial Magistrate. Chief Judicial Magistrate can do has powers to pass any sentence up to death, life imprisonment, or imprisonment not exceeding 7 years. Very simple. Sixth question. The scope of High Court's inherent powers. So Section 482 empowers High Court for all three purposes: to give effect to give orders, prevent abuse, secure end of justice. Very simple. All three things, okay? The High Court's inherent powers is basically in CrPC. Section 482 says about what? It basically says about all the three options. That is about to give effect on any order under CrPC, to secure ends of justice, to prevent abuse of process. This is a very easy question. I hope you will be able to, you are capacity to answer. Joinder of charges for same kind of offenses. Okay. For rule regarding trial of multiple offenses of same kind by same person. Permitted up to 3 offenses if committed within 12 months. What is the time period? It's basically within 12 months. Just by heart this time period. Very important. Okay. Because it is coming under section 290. Eighth question. Authority for search warrant in postal custody. So, who can issue a warrant to search for document thing in custody of a postal or telegraph authority? So, it is basically who can issue a warrant. Is it a superintendent of police, or is it a judicial magistrate, or is it a CJM or the first class, or is it chief judicial magistrate or district magistrate? So, this power is basically within the CJM, chief judicial magistrate or district magistrate. So, special provisions under section 92 related rules empowers DM, district magistrate, or CGM, Court of Sessions, High Court, to direct the Post or Telegraph Authority. So in order to inquire, these two authorities have huge power. Who is it? One is district magistrate and chief judicial magistrate. Next, ninth question. The maximum remand during inquiry or trial is what? What is the maximum remand during this inquiry or trial? The answer is should not be exceeding within 15 days. Very simple, not exceeding 15 days. 10th question. Effect of compounding an offense is basically what? Acquittal. Okay. Effect of compounding an offense is basically acquittal. Section 328, clause 8 states composition has effect of an acquittal of accused with whom offenses is basically compoundable. Very simple. 11th question. Rules of res gata. That is, under this evidence act we'll be learning now. Okay, which is not correct about res gata. Okay, very simple. Uh, Option D. Let's skip the option D and let's see which is correct about res gata. Okay, facts must be substantially contemporaneous with fact and issue. So obviously any fact should basically be q-linked with the issues. That's the first part. Second, facts must relate to and explain the accompanying facts. So one fact should be able to substantiate and explain the accompanying for the subsequent facts. Third thing, facts must relate to the act in issue. So facts must subsequently connect to the issue and then be able to explain. Okay, this is a very important aspect of res gata. Now, 12th question, dying declaration as exception. Okay, so dying declaration is an exception to which rule? It is basically to a hearsay rule. Very simple. Dying declaration are hearsay but admissible under section 32 due to special principle nemo mortis presumptive many three. Okay, very simple as that. 13th question. Evidence value of dying declaration. What do you mean by evidence value of dying declaration? Okay, let's go to the question. You'll understand the clarity. Which statement Ray dying declaration is not correct? Okay, but let's see which statement of dying declaration is correct first. Okay, can be sole base of conviction if court fully trusted. Okay, so dying declaration is a very important form of an evidences, and basically conviction can also happen at that particular stage. Now, second thing. Next is about what? If the court satisfied it's true or voluntary, conviction without further corroboration is possible. That is also possible. Yes. Now, D is what? If suspicion should not be acted upon without corroboration. Suspicion should not be acted without corroboration. That is one other thing. 14th question. Fact and issue. In a murder charge, which is not a fact and issue. So, for a murder in issue, which is not fact and issue. In a murder charge, which is not a fact and issue, very simple. It is option C, that A was too poor. Okay, by default, I think you can understand this then. For a murder charge, in a murder charge which is not a fact and issue, that A caused the murder, by default, that's the correct answer. A intentionally caused the murder, yes. That A has incapable due to soundness of mind, that is okay. So, which is not an issue if you ask, that is basically that A was too poor. So, some questions, if you look at the option itself, quickly you'll be able to give a logic and give an attempt for it. Now, discover under police custody. Under section 27, which information given by accused is relevant? Okay, under section 27, which information given by accused is relevant? The information that relates distinctively to effect thereby discovered. So very simple as that. Information that relates distinctively to the fact thereby discovered. So under section 27 allows proof of that part of the accused statement which distinctively relates to the fact discovered as a result. Oh, I hope that's very clear for you. I hope if you're reading the Barak again and again, no, it will be more easier for you. Now, 16th question. Conclusive proof of legitimacy. Only ground to rebut conclusive presumption of legitimacy is what? Only ground of rebuting conclusive proofs of legitimacy is what? Is it a DNA testing or non-access of parties to each other, psychological impotency or adultery? The answer is very simple. It is B, non-access of party to each other. So section 112 says legitimacy is conclusive unless it can be shown that the husband and wife had no access when child could be begotten. I hope that's very clear for you. Confession in police custody. Very simple. When is confession by the accused in the police custody admissible? When is confession by accused in the police custody is basically admissible? That is option D. Option A is what? When statement made voluntarily. B is about when made to his friends while in custody. Option C, when made to a doctor while in custody, when made in a magistrate in the custody. So a confession in front of the police is not admissible, but if you're doing it in front of the magistrate, it is basically admissible. Okay, confession to a police while in custody inadmissible unless it is basically made in front of magistrate. So if you're giving a confession front of a magistrate, then it is what? Valid confession. Okay, 18th question. Proof of previous conviction acquittal. A previous conviction acquittal may be proved by extract certified officer in the custody of records, B, certificate by jail officer, or production of commitment warrant, which. So that is both 1 and 2. That is about what section 395 of the CrPC sets out both methods to prove previous conviction acquittable. 19th question. Nature of test identification parade. Okay. So which is not correct about TIP. So we'll just see which is correct about TIP. Then last one we'll just excavate. Okay. Let's see. The first one is what? TIP can be used for corroboration. Is that correct? Yes, obviously. Okay. Next, TIP should be conducted immediately after arrest. Is that correct? Yes, that's true. C, TIP can be held only when accused not previously known to witness. Is it correct? That is also correct. Now, D is not correct answer. Why? TIP is a piece of substantive evidences. Why that is not correct? Because TIP is a piece of substantive evidences. TIP is corroborative, not substantive, because courts treat TIP identification as useful but not conclusive. So they will treat it as purely as an identification, but they will never treat it as a conclusive on this one. Now, 20th question is what? 20th question is very simple. The presumption. Okay, I'll just put it over here. Presumption of dowry death. Okay, section 113B deals with what? Section 113B deals with what? Let's go with directly. It's basically the dowry death. Okay, section 113B allows court to presume dowry death occurs due to the cruelty, harassment in connection with the dowry in 7 years of marriage. I hope today's video was really helpful for you. Please do learn. If you are interested to join to my classes furthermore, you can join from the below link. I'll be more than happy to guide you further. All the best. Prepare very well. And if you feel like more content I need to upload on, please do let me know. I'll be happy to support you. Wish you all the best. Good luck. This is me, Advocate Pawan, signing off. Take care. Goodbye. Thank you. If you do like this video, please do like it. Thank you.